Okay, let's unpack this. Imagine you are, I don't know, going through a messy divorce.
Oh yeah, never a fun starting point.
Right. But you and your ex finally hash it out. You agree to split your incredibly valuable company stock options 50-50.
Okay, sounds fair so far.
Yeah. So the ink dries on the family court settlement, you breathe a sigh of relief, and instantly, magically, a massive chunk of the value of those options simply evaporates into thin air.
Just gone.
Completely gone. Why? Well, because the IRS just decided to punish you for the transfer.
It is a brutal reality. I mean, we tend to think of corporate equity plans as these rigid, perfectly engineered documents, you know?
Yeah, absolutely.
You get a grant, it vests over 4 years, you exercise, you sell. It feels like a clean, predictable spreadsheet.
Right, but that spreadsheet assumes a perfect static world, and the real world is, well, it's anything but static.
Exactly.
So today, we are looking at what happens when the immaculate, pristine rules of equity compensation collide violently with the absolute chaos of real life.
The messy stuff.
Yeah, the messy stuff. We are talking about death, divorce, market crashes, and the relentless corporate grind to keep these programs funded.
It is the ultimate stress test for any equity administrator or legal team.
For sure.
And frankly, understanding these collision points is the difference between mastering the subject and just, memorizing definitions.
Which brings us perfectly to our mission for today's deep dive. We are taking a highly targeted approach here.
Yes, very targeted.
We are not just summarizing concepts. We are actively prepping you, the listener, for your upcoming exam on the advanced issues in equity compensation.
Right, pulling from chapters 7 through 10.
Exactly. We are pulling all the most critical, testable insights on these life cycle disruptions straight from your source material.
So treat this as your masterclass study session.
And to keep you on your toes and make sure you are really absorbing this, we are going to sprinkle 3 specific knowledge check questions throughout our conversation today.
Got to make sure you're paying attention.
Exactly. So let's start with the most personal and legally fraught scenarios. The unexpected intersections of equity with death and divorce.
Because equity isn't just a corporate ledger item, right?
No, not at all. It is a deeply personal asset. Often it's someone's most significant source of wealth.
Yeah.
Let's look at the mechanics of handling an employee's death first. I can only imagine the administrative scramble here.
Oh, it's intense.
I mean, an employee passes away, and suddenly the company has to figure out legally who gets to touch these shares.
It is an incredibly delicate time, both emotionally and legally.
I bet.
The plan administrator suddenly finds themselves thrust into the world of probate and estate law.
Right, which is not what they signed up for.
Not at all. They aren't usually dealing with the grieving family directly, but rather the estate's designated representative or, the trustees of a trust.
Okay, that makes sense.
And their immediate job is to figure out if the options are transferable, if the vesting schedule accelerates upon death, and how long the estate has to actually exercise those options.
And when I was reviewing the precedent here, the tax and securities nuances are where people really trip up.
Big time.
Let's talk about incentive stock options, or ISOs. Usually, the IRS is incredibly strict about ISOs.
Very strict.
To get that sweet, favorable tax treatment, you have to hold the shares for 2 years from the grant date and 1 year from the exercise date.
Right, the standard holding periods.
But when an employee dies, the rules actually bend a little, don't they?
They do. The IRS recognizes that a deceased person's estate didn't exactly plan the timing of this event.
Obviously.
So the standard holding periods, that 2-year and 1-year rule, are entirely waived for the estate or the heir who inherits the options.
Okay, so they get a pass on the holding period. But wait, there is a catch with the limits, right? I mean, the IRS never gives a complete free pass.
Never. And this is a massive trap for administrators.
Tell me about it.
There's a statutory rule that only $100,000 worth of ISOs can become exercisable for the first time in any single calendar year for any individual.
Okay, let me make sure I'm getting this. If an employee dies and the company plan automatically accelerates all their unvested options as a benefit to the family, that could easily push the value way over that $100,000 limit in that specific year, right?
Exactly. The holding period requirement might die with the employee, but that $100,000 statutory cap most certainly does not.
Wow.
If that acceleration pushes the value over the limit, the excess automatically loses its ISO status.
And it becomes a non-qualified stock option, an NSO.
Precisely. So the estate suddenly has a very different tax situation on their hands.
That is a crucial detail for you to remember for the exam. The cap survives.
Always.
Now, there is also this incredibly intimidating acronym that pops up when dealing with cash-settled awards after a death IRD.
Yes. Income in respect of a decedent.
Yeah, when I see IRD, it basically flashes like a neon warning sign that says, get a tax professional immediately.
And you should.
What exactly is IRD, and why is it such a compliance nightmare?
Well, think of IRD as ghost income.
Ghost income. Okay.
Let's say you have a restricted stock unit, an RSU, that is designed to settle in cash.
Right.
The employee dies before it pays out, but they had already earned the right to it. That income wasn't recognized on a tax return before they died.
Gotcha.
When the company finally pays that cash out to the estate, the IRS classifies it as income in respect of a decedent.
So it means the tax burden transfers to the estate or the specific beneficiary who receives the cash.
Exactly. It shifts the liability in complex ways.
Ah, so the company could accidentally trigger a massive unexpected tax bill for a grieving family member if they don't report and withhold it correctly.
Yes. And if the administrator miscodes it, the penalties and the legal headaches are severe.
Okay, so that's death. Let's move from the complexities of death to the complexities of divorce.
Another minefield.
Yeah, this is fascinating because courts view equity awards, even unvested ones, that the employee hasn't technically earned the full rights to yet as marital assets subject to equitable distribution.
They are property earned during the marriage, plain and simple.
Even if they aren't vested.
Even then, it doesn't matter if only the employee's name is on the grant agreement. The family court wants its piece to divide.
Right.
And this introduces a completely new external player into the closed corporate ecosystem, the NEFS.
The non-employee former spouse.
Exactly.
And from a corporate perspective, handing stock over to a random non-employee is a huge securities law hurdle.
It's massive.
Usually issuing shares to anyone requires registering those shares with the SEC, which is an expensive process designed to protect people from being sold fake or untradeable stock.
Yes, but thankfully, the SEC offers a measure of grace here.
Oh, they do?
Yeah, they understand that a divorce decree is a court order, not a standard corporate stock offering.
Okay.
So shares that are issued to a non-employee former spouse by a public company are actually covered by the company's existing Form S-8 registration statement.
Which is the standard form companies use to register shares for their own employees.
Exactly right.
So the SEC basically says, okay, we'll treat the ex-spouse like an employee just for the purpose of moving these shares legally.
Correct. It saves the company from making an illegal, unregistered securities offering just because an employee's marriage ended.
But let me circle back to the scenario I opened the show with. The evaporating ISOs.
Oh, yeah. The vanishing value.
If I have a bunch of incentive stock options and my divorce decree says I have to give half of them to my ex-spouse, why isn't it just a clean split?
It seems like it should be, right?
Yeah, like dividing a bank account. I take my half, they take theirs, and everything stays exactly the same.
This is where we have to look at why ISOs exist in the first place.
Okay, why?
The IRS created incentive stock options specifically as a statutory tool to bind an employee to their employer. The favorable tax treatment is the reward for that loyalty.
Okay, I follow that.
So what happens when you transfer that option to someone who doesn't work for the company?
The statutory purpose is broken.
Exactly. The IRS absolutely forbids that clean split. The simple act of transferring an ISO to a non-employee former spouse in a divorce settlement destroys its ISO status entirely.
So the moment it leaves the employee's hands,
It becomes a non-qualified stock option for the former spouse. All that preferential tax treatment just evaporates.
because the ex-spouse isn't an employee, so the IRS refuses to give them an employee tax break.
You got it.
That makes total logical sense when you explain the why behind it. Now, what about RSUs, restricted stock units?
Oh, this is tricky.
I've heard there is a massive trap here involving Section 409A of the tax code.
Yes, there is.
If I'm getting divorced and I just want to clean up the asset split, why can't I just ask my company to accelerate the payout of my RSUs right now to satisfy the divorce decree?
Because of Enron.
Wait, Enron? Like the accounting scandal from the early 2000s?
Exactly that, Enron. Section 409A was born out of the Enron disaster, where executives were manipulating the timing of their deferred compensation to cash out before the company collapsed.
Oh, wow. I didn't realize the connection.
Yeah, so the IRS created Section 409A with incredibly rigid, inflexible rules about exactly when deferred income, like certain RSUs, can be distributed.
So you cannot just change the date because it's convenient.
Nope.
So even a court-ordered divorce doesn't count as a valid reason to speed it up?
not to the IRS. Divorce is not a permissible distribution event under Section 409A.
Okay, so what happens if they do it anyway?
If an administrator accelerates an RSU specifically to satisfy a family court settlement, they are violating federal tax law.
Yikes.
And that triggers a devastating 20% penalty tax on top of regular income tax levied directly against the employee.
That is brutal.
It is. The IRS does not care about your family court settlement. Their anti-manipulation rules still apply.
Incredibly important to know for the exam. All right, it is time for our first knowledge check.
Let's do it.
I'm going to ask a question, give you a second to think, and then we will give you the answer. Here is knowledge check question 1. If an employee transfers a portion of their incentive stock options to their former spouse in a divorce settlement, what happens to the tax status of those options?
And the answer is they lose their statutory ISO status entirely and are legally treated as non-qualified stock options from the moment of transfer forward.
Excellent. Okay, so we've seen how an individual's personal life, like a death or a divorce, can drain shares from a company's equity pool or force unexpected payouts.
Right.
But zooming out, that creates a macro problem for the company. How do they keep that overarching pool full of shares?
That's the constant struggle.
Because companies need a constant supply of equity to grant to new hires and retain existing talent.
Yeah.
But going to the shareholders every single year to beg for permission to create a new pool of shares sounds like a grueling, expensive proxy battle.
It is a total nightmare for management.
I can imagine.
The proxy process takes months. It costs a fortune in legal and mailing fees, and you are never guaranteed the shareholders will actually vote yes.
So enter the Evergreen provision.
Yes.
As I understand it, this is a mechanism built directly into the equity plan document that automatically replenishes the share reserve every single year, usually by a set percentage.
That's the basic idea.
I like to think of it as a corporate subscription box for shares. You just set it to auto-renew, the shares show up on January 1st, and you don't have to ask permission anymore.
It is a subscription box, but let's build on that analogy to understand the friction here.
Okay.
Imagine if every time your subscription box of shares arrived, it automatically diluted the value of your neighbor's houses.
I see. Because there are more shares in existence, so every individual share is worth a tiny bit less. The pie got bigger, so my slice got relatively smaller.
Precisely. That is why shareholders, and particularly the powerful proxy advisory firms like Institutional Shareholder Services, ISS, absolutely loathe Evergreen provisions.
They hate them, huh?
Oh, they view it as an automatic, unmonitored dilution machine. Shareholders want oversight.
Which makes sense.
If management wants to dilute the stock, investors want them to stand up at an annual meeting and justify exactly why they need it.
And an Evergreen provision removes that ongoing shareholder oversight completely.
Exactly.
So getting an Evergreen provision approved by shareholders in the first place must be a monumental task. When you dig into the tax code, there are some very strict legal requirements around this, aren't there?
Highly strict and very likely to be on your exam.
Listen up, folks.
If your equity plan issues ISOs, or if it is a tax-qualified employee stock purchase plan, an ESPP, the federal tax code explicitly requires shareholder approval to add an Evergreen provision to the plan.
You cannot just have the corporate board of directors voted in behind closed doors.
No, because an Evergreen provision inherently increases the maximum number of shares that can be issued under these tax advantage programs. The IRS demands that the actual owners of the company, the shareholders, sign off on it.
Got it. And beyond the tax code, there is an administrative trap attached to this subscription box, too.
Oh, a massive one.
We talked about Form S-8 earlier, the SEC registration document. Does an automatic share refill mean automatic SEC registration?
It absolutely does not. And this is where plan administrators fail all the time.
Oh, boy.
The Evergreen provision automatically adds shares to the internal plan document on, say, January 1st.
Right.
But those new shares are not automatically registered with the federal government. The company must actively, manually amend its Form S-8 every single year.
To register those newly created Evergreen shares before they're issued to any employees.
Exactly, before they are issued.
Wow. So the subscription box arrives on your porch, but if you don't call the SEC to tell them you opened it, you're suddenly handing out unregistered illegal securities.
That is exactly the compliance failure you have to avoid.
All right, let's see if you caught the nuance on who actually has the power here. Time for knowledge check question 2. True or false? A company can freely add an Evergreen provision to a tax-qualified employee stock purchase plan without shareholder approval, as long as the board of directors unanimously agrees.
And the answer is false. Shareholder approval is explicitly required by federal tax law to add an Evergreen provision to an ESDC or an ISO plan. The board cannot do it alone.
Nailed it. So we figured out how to keep the share pool full with an Evergreen provision.
Right.
But what happens when the broader stock market tanks, the company's stock price plummets, and all those newly minted shares in the pool are suddenly worthless to the employees holding the options?
This is the third major collision we need to cover salvaging sinking ships. Specifically, the repricing of underwater stock options.
That sounds incredibly stressful.
It is a terrifying scenario for a board of directors. I mean, the entire point of granting equity is retention and motivation.
Yeah.
When an option goes underwater, meaning the current market price of the stock is far below the strike price the employee has to pay to exercise it, that option has zero tangible value.
The retention tool suddenly transforms into a retention liability. Your top engineers look at their worthless options and decide to jump ship for a competitor whose stock isn't in the gutter.
Exactly. So the company feels immense pressure to fix it, usually by exchanging the old, worthless options for new options at today's lower achievable price.
Okay, but let me push back here on behalf of every angry investor out there.
Sure, go ahead.
If the stock tanks and a company just hits the reset button and hands out new, cheaper options to the employees, doesn't that defeat the entire philosophy of tying pay to performance?
It absolutely does.
It sounds like a total free pass for failure. Like, you guys crashed the stock, but here's a fresh batch of cheap shares anyway.
And that is exactly why the accounting standards boards and the shareholders intervened.
Oh, they did.
Yeah. Historically, back in the 90s, companies would just do a one-for-one exchange. You turn in one underwater option, we give you one brand new option at today's low price.
So it was basically free for the company to do.
Exactly. Okay. And the accounting rules changed, specifically a rule called ASC 718.
Before my eyes glaze over from accounting jargon, what did ASC 718 actually do to stop this?
Well, ASC 718 established that stock options have a quantifiable accounting cost to the company when they are granted.
Okay.
If you just hand out brand new, cheaper options, the accounting rules say you are granting new compensation.
Ah.
That means the company would have to record a massive, ugly new expense on their income statement, tanking their earnings even further.
So how do companies fix the underwater options without triggering that massive new accounting expense?
They shifted to what's called a value-for-value exchange.
Value for value, okay.
Under this model, the new options granted must have the exact same accounting fair value as the old underwater options being canceled.
Wait, how does that math work? If the old ones are underwater, aren't they worth less?
Yes, and because the new options have a lower strike price, they are inherently much more valuable per individual share.
Right.
Therefore, to make the total ledger balance out perfectly, the employee receives significantly fewer options than they surrendered.
Ah. So it's not a one-for-one free pass anymore. If I have 1,000 underwater options, I might only get like 300 new viable options back.
Exactly. That makes the exchange value neutral from an accounting perspective. There is no massive new compensation expense hitting the income statement.
And crucially, I'd imagine it is much more palatable to shareholders because it results in less dilution.
Definitely. The company is issuing far fewer new shares.
That makes total logical sense. But doing this isn't just an internal HR exercise, is it? The SEC gets heavily involved here. Why does the SEC view exchanging employee options as a regulated tender offer?
Because you're fundamentally asking employees to make an investment decision.
Okay.
The company is offering to buy back the underwater options in exchange for new security. The SEC views any repricing that requires employee consent as a self-tender offer.
And because it is a tender offer, it falls strictly under Regulation 14E of the U.S. securities laws.
That's the one.
And what does Regulation 14E demand of the company?
It is all about giving the investor, in this case, the employee, time and information.
Makes sense.
It requires that the exchange offer must remain open for a minimum of 20 business days.
20 business days. Got it.
Yeah. The company has to provide extensive documentation detailing the exact purpose of the offer, the risks, the valuation math, and basically give employees ample time to consult financial advisors and decide if they actually want to participate.
And does everyone get a life raft? Like, if I am the CEO or a board director who steered the corporate ship into the iceberg in the first place, do I get to trade in my worthless options along with the rank-and-file employees?
Almost never.
Really?
Proxy advisors and institutional investors will aggressively push back if executives are included. The general rule is that executive officers and the board of directors must be explicitly excluded from repricing programs.
Oh, that's interesting.
Yeah, if they're allowed to participate, the proxy advisors will almost certainly recommend that shareholders vote against the entire repricing proposal, killing the program for everyone.
Now, before we hit our final knowledge check, I was looking into the historical precedent here, and I have to ask you about the anomaly from 2007.
Oh, Google.
Yeah. Google, working with Morgan Stanley, did something that completely blew my mind. They didn't just reprice options, they literally created a secondary market for them.
He was incredibly innovative, wildly complex, and rarely duplicated since.
Right.
Instead of a standard repricing or value-for-value exchange, Google allowed its employees to sell their underwater options to financial institutions in a competitive blind bidding process.
But wait, why on earth would an investment bank pay real money to buy an employee's worthless underwater stock option?
Because of a concept called time value.
Time value.
Yeah. Even if a stock option is underwater today, if it still has, say, 5 years until it officially expires, it is essentially a lottery ticket. There is a mathematical probability that the stock price could recover and soar before that expiration date. Financial institutions were willing to pay a premium for that potential, that time value.
That is so smart.
It allowed Google employees to extract immediate cash value from options that otherwise seemed completely dead.
Well, if it's such a massive win for the employees, why doesn't every tech company do this when their stock drops?
Because it is an administrative nightmare.
Oh, I bet.
It required massive, unprecedented regulatory filings with the SEC. It required the banks to engage in complex hedging strategies to manage their risks.
Right.
And most importantly, it required a core equity plan document that actually allowed options to be transferred to third-party institutions, which almost all standard equity plans explicitly forbid to avoid exactly this kind of complexity.
Wow. A fascinating piece of corporate history that proves just how creative you can get when you really understand the mechanics. Okay, let's lock in this repricing knowledge. Here is your final knowledge check for the deep dive.
Number 3.
Knowledge check, question 3. Because the SEC views an option repricing program as an investment decision and a self-tender offer, what is the minimum number of days the exchange offer must remain open?
And the answer is at least 20 business days, as explicitly required under U.S. tender offer rules, specifically Regulation 14E.
Fantastic. Well, congratulations on making it through this masterclass exam prep session. We have covered a tremendous amount of ground.
We really did.
We navigated the incredibly delicate handling of equity when an employee dies, breaking down how the ISO caps survive, and dodging the ghost income tax traps of IRD.
Very important stuff.
We looked at the destruction of ISO status during a divorce and the Enron-era 409A penalties.
Yep.
We explored the deep shareholder friction surrounding the dilution of Evergreen plans and the strict SEC requirement to manually update those S8s.
Got to update the S8s.
Always.
Yeah.
And finally, we unpacked the strict 20-business-day tender offer rules of repricing underwater options using value-for-value math. You are well armed for your test.
You absolutely have the foundational knowledge. But before we go, I want to leave you with something to ponder that extends a bit beyond the textbook rules we just covered.
Oh, let's hear it.
Everything we discussed today, from the rigid 409A timing rules to the intricate Form S8 registrations, was originally designed for a very traditional, stable, single-employer career trajectory.
Right, the 1950s corporate model.
Exactly. It assumes a world where someone works for a corporation for a decade. But look at the trajectory of the modern workforce. Employment is becoming vastly more mobile. The gig economy is exploding.
It really is.
We are even seeing the SEC toy with temporary S8 rules just to figure out how to grant equity to independent platform workers and contractors.
That's a whole new frontier.
It is. So as the lines of traditional full-time employment continue to blur, how will these rigid decades-old frameworks for death, divorce, and repricing possibly adapt?
Good question.
How do you administer a complex 20-day underwater option exchange for a decentralized workforce of 10,000 independent gig workers?
The friction between the static rules and dynamic reality is only going to grow. It is definitely something for you to think about as you pass your exam and step into the real world of equity administration to help solve these exact problems.
Good luck out there.
Thank you so much for joining us on this deep dive. Best of luck on your exam. You are going to crush it. We'll catch you next time.